Well, hello, everybody. I hope you're ready to work. I know there's a lot going on. Hopefully, you're healthy and at home safe. But we know that there is a lot going on in your life. So, there are things that you're going to need to work on because not everything in life stops. So, today we're going to go over strategies for establishing clear rules of law. And I'm going to introduce you to the reasons why you want to make parental rights arguments. So a lot of people they encounter attorneys who say they don't want to make these arguments, and a large part of that reason is because those attorneys don't either think that you can handle it or they don't want that rule of law established in the areas where they practice. So for a long time, many years I've been reading. I'm Sherry Palmer, by the way, with Fixed Family Courts. I'm not an attorney, don't practice law. I haven't been to law school. I learned most of what I know from studying, just like all of you, when I was going through the situation. But then I continued my studies with my husband, Ron Palmer, and we have since published 4 books in the family law space. And he has a book that he published in the business space in IT in before he went through his divorce as well. So we have extensive experience, not just in our own case, but also working with other attorneys and other parents. So parenting us into their cases to help them with these arguments. But I'm going to show you an easier way to get a hold of these arguments too. So don't worry, you're not going to have to spend as many years as my husband and I have crafting and figuring out this messy, broken system with substantive rights and procedural process and all of that. So we're going to give you some shortcuts on that. So what we're doing is let's focus on an area that you're familiar with. Okay, you're going to be familiar with being accused. Let's say you got accused of some kind of abuse allegation that's going on, and maybe you're using certain defenses your attorney has suggested, and all of a sudden the other side has accused you of parental alienation. Okay, and we're going to be using this whiteboard pretty soon, and I will turn it so you can see it. But don't worry, if you can't see the whole thing right now, you don't need to. So why is all of this important? Because abuse allegations are used to essentially cut you off from access with your child, right? And you don't even have to have been proven unfit. You don't even have to have been convicted of any of the things you were accused of, but you get cut off. Isn't that true? So that's why it's important that you learn how to do this. And how many of you are actually having trouble finding attorneys to argue that you have rights in those cases, even though they are quasi-criminal, right? If they don't choose to take the allegation all the way to a criminal case, then they get couched in family law. And then they say they don't want to apply any rights. They constantly say it's about the best interest of the child, the best interest of the child. We're not going over that best interest stuff tonight. We're just going to help you walk you through why this is important, applying your rights throughout the process, and you can get that in your mind, how it works, where it goes, what the process is. So we're going to actually outline that process for you today. So a big objection is that parents not only have trouble finding attorneys to make the arguments, but also difficulty understanding what arguments you need to make, right? And then the next problem is, and don't worry about that, about figuring out the arguments you need to make. No worries, we've got that covered. So the next objection then would be educating that attorney, right? You're not really sure how to do it. How many of you believe that in order to win equal custody, talking to your attorneys? Well, why aren't you looking at this? Why wouldn't you look at that as when you're teaching them the parental rights that you want applied, or your children's rights? why isn't that being looked at as you are educating an ally? So you should be looking at your attorney as they are, or they should be, an ally to you in court. If they feel like they're causing you more stress, you feel like they're causing you more stress, or they're not consulting or conferring with you before they craft strategies, that's probably not going to be a candidate for using parental rights. So for example, if an attorney tells you, don't tell me what to do, either you're presenting it to them not quite right, or they're not the right attorney. But I would say it's probably the latter, that they're not going to be the right attorney. So I'm looking at my notes so I can remember and stay on track for you guys. So just give me 1 second here, because I got distracted because somebody posted something to me on my phone. So in order to train your attorneys how you want this litigated, you're going to have to teach them why it's important, because they know you're getting cut off from your child. So that's not going to be a good enough reason for them. And attorneys know that that we're teaching you tonight is essential, because they will use it in other areas that they argue. So for instance, if they had a case where, or one of their other attorneys that they know who handle domestic abuse cases, the ones that represent parents who have been abused, right? So they're the plaintiff. They will be trained to actually make the arguments that certain substantive rights are being violated. For instance, domestic violence groups will teach that that it's the First Amendment right for a mom to have a belief that she's been abused and that she shouldn't be cut off from her child for having that belief, right? So should you be cut off for your beliefs and your values? Aren't those First Amendment violations too? Absolutely. So somehow they believe it when they're defending somebody, when they believe that you've done something bad to them, but they don't want to believe it when you're telling them that it applies to your right to association, your right to raise your child how you want. All of a sudden, well, not that they don't believe it, but they won't make that argument for you. And they are told to challenge the judges when the judges don't let them make the arguments about their parents' rights when that parent was abused. I'm making you aware of this. There's actual training out there. They teach attorneys to do that. They even teach those attorneys to challenge the judges. They teach them to ask for recusals of the judge. They teach them to insist on rulings about their arguments, and then to quote case law like Stanley. And they teach them, and in fact, they teach them to quote a lot of federal case law, and they teach them to make sure that they litigate the federal rights all the way through the process. So one of the things that we make clear here is where what we produce goes into the process. It goes through the whole process, not just in one section. So they're teaching domestic violence attorneys that they've got to litigate your federal rights, your constitutional violations, all the way through the process. So if there's a procedural violation, let's say they have a gal and that gal produces a report and they don't get to challenge the report and they don't like it, they will call that a procedural violation. And they teach them to argue that all the way through, argue against ex parte communication, all those things that you guys have been arguing. Evidentiary issues, they teach them to argue those. So don't feel shy when you're insisting for the same representation and the same arguments. And if they push back, then bring that up. All right. So in our classes, we're going to give you the link so you can read the same education that attorneys are getting. So when you get an attorney who pushes back on you, no, rights don't apply in family court, then you ask them, did they ever go to any of this training? And then if they didn't apply, why are they being taught that they apply? Right? So, so what's the next thing I want to cover with you? Okay. So they also say that they'll get threatened for using the arguments, or that the judge will get upset with them. Well, they've been trained that judges will get upset sometimes, but they have also been taught to Okay, so we have a little glitch there. I don't know what happened, but I'm back. So they will, where were we? Oh, they will tell you that they're going to get threatened, and they are taught to expect that actually when they challenge a judge, that the judge could become upset, and what they're supposed to do is talk to you about that and then measure whether or not that's a good strategy for your particular case. Okay. And I would imagine, like I said, I'm not a lawyer, but I would imagine a lot of it would depend on how strong the other side's allegations are coming across and how likely it is that, how much evidence you have to counter that in order to pressure that judge, right? They don't want the judge becoming more punishing to you, and there's lots of other factors they're going to take into consideration. So you'll have to ask them what those are. Again, don't be shy. Make sure you get clarity on these things, and then make sure your attorney is making clear and concise arguments to your judge, right? So the other reason that you want to make these arguments is because this is a very long process that you're going through, and that means it's going to require you to make really good money choices. So if you just go through the process the traditional way, where you get in, they tell you, let's go through mediation, let's do a whole bunch of discovery, let's ask for experts and gals and stuff like that, it's going to be super expensive. So doing it the way I'm going to outline for you is going to save you a ton of money, and I'm going to show you how that is. And then we're going to go over a little bit about how much does it cost. So now I'm going to show you this board, okay? So you need to make sure that you're putting all the right arguments together. Let me turn this. I'm just trying not to drop my phone here. Arguments and powerful ones. And you can't see the top of my board. So let me back this up. Just bear with me here. I want to make sure you can see this whole board. There we go. All right. So the top of the board, I have what the average cost is for high conflict litigation. And yes, I like lots of colors of pens. Easier for me to work with different stages. There's a lot of process here. So we're trying to color code some of the stages too. Okay, so the average cost I went with was $70,000. You might find online they'll say like $35,000 for a divorce, but you all know that if you're being accused of false allegations, and even if you're not, even if you don't have to fight off some kind of potential criminal thing, you're easily going to spend $70,000 or anywhere between 35 and 70. So let me show you. Okay, there's 5 subsections that go on throughout this process, right? I went over 5 stages in a previous video. These are within those 5 stages. So there's also 5 subsections side, and then we'll go over some of the costs associated with that, okay? So framing your case, we're just going to call it FYC. That's the first sub-stage, right? And then the second one is making the record, right? And that's where, well, let me back up here. Framing your case is this whole process. So I messed up already. That's why I have this handy eraser. Framing your case is the whole process. Okay. So creating your record, developing the record is what we call it, right? So DTR. That's what you're going to do all throughout your trial, right? And before, pre-trial and throughout your trial. You're going to develop the record. We're going to go over a little bit what's in that. And number 2 is you're going to be educating the judge throughout this process, right? Because what are we doing? We're creating, we're establishing clear rules of law. So regarding parental rights, because they say that you don't have any in the family law process. So you have to establish those clear rules of law for them. And 3 is post-trial motions, right? Post-trial motions. And then 4 is going to be your appeal. We're going to tell you briefly what you need to know about this throughout this process. Okay, you don't want to wait until appeal to learn about appeal. And then the 5th is you're litigating your federal rights throughout the entire process, right? So that's all the way through. So it's your federal, actually, we're going to call them uh, your federal constitutional violations. So we'll just call them FCC. Don't get confused. It has nothing to do with FCC and the agency. Okay, so your federal constitutional violations all the way through. And why federal? When you're in state court, right? Because the state court has the authority to rule on your federal rights. And the federal courts don't want to hear these child custody cases. So we've actually updated our materials to make it easier for you. And our fourth book that we wrote, it's an orange book that you'll find on our website, is about making it easier for you to understand how to articulate these federal rights throughout the process, right? It simplifies your parental rights arguments. Okay, so I'm going to start here. We're going to start with building your record, making the record. What's involved in that? So first of all, you're going to have to, what do you do when you go to an attorney after you're served or after you, or while you, if you're thinking of serving the other parent or you've been served, you're going to go to an attorney, and what are they going to ask you for? They're going to ask you for a retainer, right? So you're going to pay the retainer, and that's going to be anywhere. We're taking averages. I'm going to have all over the board, but that could be anywhere from, let's say, it's high conflict, right? So maybe we're just going to say 5 to 10,000. Okay. You can write out the number, put a K. So that's where you start, but that's not what finishes it. And a lot of people don't realize that this 5 to 10,000 is not even going to come close to finishing your case. And by the way, this 70,000 does not calculate in any expert costs, guardian ad litem, or amicus costs. Okay. So there's a lot more to this. Okay, so so in build the record, what are we doing in develop the record here? We are making sure that we're raising on the record federal constitutional issues. Our motions package on our website. Our website, by the way, is www.fixedfamilycourts.com. So that's in our motions package. I'm going over applying the motions package to these stages. Why? Because that's where I said, don't worry, we've got a handle. We've simplified all these arguments. And the whole point of doing all of this is making the right arguments so you can move this clear rule of law so that it solves it for everybody after that, right? How do you do that? You have to have arguments to make, and you've got to have a strategy that everybody uses those arguments. Otherwise, Supreme Court's not going to hear it if everybody's making different arguments. So it's not about you have to tell every organization to work together. It's nice when we all work together and help promote each other, as long as we're all still doing what makes us strong, right? So not consuming each other, but working together, mean knowing when the right arguments are there and then moving forward with those and continuing to teach them, even when they lose. So a lot of people have said, well, I only want to use an argument if it's won. Well, this is how you win. Even if the arguments keep losing and getting denied, even if they get denied at the Supreme Court level, you don't change your arguments. Why would you change the argument that it's your right to associate with your child and your right to share your values and your beliefs with your child is protected by the First Amendment? That wouldn't change. So what we do is just we've made the arguments for you, attached them to the case law, and articulated them in a way that they can't defeat. Okay, because if you just go in there and just say that in general, they're going to deny you, and they're not going to believe that you can defend it at the appellate level. And you haven't actually developed the record like that. Just throwing that out there and not actually arguing it fully or knowing how to fully clearly articulate it so that they can develop a rule of law is the problem. Okay, and we're not going over that into super detail here. We have that all in the package already. And by the way, when we get for a minute, we are going to have like model appeals. So we've modeled an appeal argument for you, so you'll be able to see that. And then we have in the motions package, those are like modeling motions, right? They're not file ready. You have to customize them to yourself, but you're going to get all of those things. Let me see here. Just want to see. So a model cert petition, things like that. And how the federal issues have been previously raised in state court, and the areas where you should keep raising them that way. Okay, so you don't want to change an argument just because it lost. You just want to change one if it's the wrong argument. Okay, so what else in making the record? And you guys can comment here if you can think of things. So when you're framing your case, what else do you want to put? You want to make oral and written arguments, right? So we've got that handled because our written arguments are there, but also what else do you want to make? Oral and written objections. Okay. And I can't see your comments right away when I'm doing this. I'm trying not to get distracted. We'll look at them after. So you're going to make oral and written objections in timely fashion. If you don't do that, then you could lose out on being able to continue to make a certain argument. You have to raise it. And I think I'm seeing people comment and they're just kind of popping up and disappearing. So like I said, I'll try to go back to them. So go ahead and make your comments. The next thing is you want to make sure that you also request the judge to make rulings on anything that you ask for. And if you make an objection, also know that you can defend that, or not objection. If the other side makes an objection to something that you are asking the judge to do, you also have to know how to defend that. You got to do all of that in this process. Also, you do not want to have conversations in the courtroom where they're not on the record. Or if you don't have a court reporter, what's the reason for that? That's not developing the record. You won't be able to use that on appeal. And you don't want to try to go forward with an appeal where there's no record, because the appellate courts have a precedence where they are going to presume that the judge had everything they needed in order to rule the way they did, and you have to overcome that. It makes it lawyer for other reasons on that. I'm just kind of giving you things to touch on so you know what direction to go if you're looking for more information in that area. Some of you aren't aware of these things, and just by becoming exposed to this information will help you find the things you need. Remember, when I went through it, I didn't know the term parental alienation. And once I learned it, I found so much material that was so helpful for what I was going through. I was able to then catalog it, organize my arguments better, and make more effective arguments once I understood what things were called and what they meant and what went under those categories. And that's what we're trying to do for you. So also, how would you keep that record? How would you make that record? You need a court reporter. If your courts make recordings, that's good too. Because some courts, they just have recordings and you later have to go get a court reporter for them. But also make sure you take notes, because I've heard a lot of parents complain that there are pieces missing, even from recordings. They're not infallible, so they could leave out some things. Okay. And you want to challenge anything procedurally along the way that you feel is violating your rights. Say, for instance, a child gets interviewed and you don't get to challenge whatever was brought up in that interview that's now being used against you to violate your rights, right? So you need to know how to challenge that. Let's say an amicus or a gal submits a report, you don't get to challenge it, you don't get to cross-examine them, things like that. You need to raise those violations or you'll lose it. You'll lose those. You will have waived those arguments. Section is you are going to use case law to establish that you have the right to make these of the court, right? So most parents, they know that Stanley has certain rights Stanley has created protections for certain rights, right? And so a lot of parents are familiar with that one, especially single fathers. That was about a single father who went to fight for rights to his child after the other parent died, right? So we're not going to go into a lot of details on those cases. You can look at other videos in our membership site for that at fixedfamilycourts.com/membership. Okay, so you're going to want to cite to a lot of case law and other legal authorities. And also, you're going to want to give examples, and you're going to want to explain to the court why you think it applies to you. Because another case people are going to cite is Troxel, and the court is going to try to say you are in parent versus parent, and that was a grandparent case, doesn't apply to you. So you have to know why and how that is actually a parental rights case. Okay. So the other thing is you're going to be told, in order to educate the court or the judge, you're going to be told to bring in experts. That's where you get told to ask the court for a guardian ad litem or an amicus. Big mistake, because guess what? How much is that going to cost? Let's do an average. Okay, first of all, they are attorneys and they charge hourly like the attorneys, and you're going to need them there for every hearing, right? Because otherwise the court's not going to hold the hearing, because they say that the guardian ad litem has to be present at every hearing. So the gal is going to charge you, let's say, $200 an hour, okay? Because they're an attorney. And that means for every hour that your attorney spends on your case, this gal is also spending on your case. So you're going to be lucky if that gal doesn't end up costing you $35,000 with a high conflict case that has a lot of allegations in, that has parental alienation going on, that has, just so many different different variables and moving pieces. And then when you start making your parental rights arguments, now they're going to get involved. And part of educating the court may be that, and we're going to tell you to do this, you're going to want to ask for permission to file trial briefs, because trial briefs clarify your arguments. And that way your attorney can take less time in the actual hearing. Okay. So you're going to go up, and every time the gal feels that they need more time to go interview the child or interview somebody else, you may not even be able to get a hearing because the gal's going to say they're not ready. So it also costs you a lot of delays, costs you a lot of money, a lot of delays, and you're paying dual attorneys. So unless you're super wealthy, you're probably not going to be able to afford to stay in this if you have a gal, because then you're also going to probably have an expert witness, aren't you? Because maybe the gal doesn't believe that you're being alienated, and now you got to bring in a parental alienation expert. Or maybe it's the other way around. You're trying to counter that there's parental alienation in it. So you just see it starts layering on a lot of expenses. We're not going to go over how much each of those cost, because that differs as well. But sometimes when a gal's already in there, we have had success with limiting them to just like, I think the last time was like $3,000. Whereas before, that very same parent who had gone through the whole process before that, their gal cost them $100,000 in 6 months. Okay. And this time it was like a year case, and they ended up costing them, actually it might have been more than 3,000, might have been more, upwards 6 or 7. A lot of numbers go past my desk this with these issues, but the point is, it didn't cost them $100,000, and no, they shouldn't have asked for a gal. They actually were the ones who asked, the ones who were trying to argue their parental asked for a gal before they were arguing their parental rights. So they tried, their arguments were to get the gal off after that, invoking that request. Okay, so you're educating the court. What else is involved in that? You guys know? We've got the briefs. We've got, you don't want to have to bring in a bunch of expert witnesses. What else could you do to educate them? You could, and we've got cite case law or legal authorities as often as you can. Anything else you can do? So we'll see what you guys comment on that, and then I'll comment in the video to tell you what that is. So watch all the way to the end to get all this information. I'm not going to give this one to you yet. Okay, so what's the next thing? The next thing would be after you've educated the court, right? Now you're going to go to your trial. So the trial is under here. So you've had pretrial, you've had trial. What else have you had? Mediation, probably. You've also had a bunch of probably temporary orders hearings. So all of this is built up into this expense so far, hasn't it? Every time you need to change something, you might have had Rule 11s. You might have filed a mandamus, and mandamus, if you don't know what that is, again, get into our membership site or look it up online. The benefit of our membership site is you're going to get very focused information that associates to your parental rights arguments, and you're going to find suggestions on arguments to make, so you don't have to spend all that time doing it yourself. Because guess what? If you also try to get your attorney to study all of this and come up with all their own arguments, then you're going to increase your expense again, right? And we don't want you to do that. So the next thing is if you didn't get what you were trying to solve in the trial, right? Let's say you were trying to go for equal custody and you didn't get it in the trial. Now you've got your post-trial motion period. And guess what? Usually this cost right here has not calculated in the cost for post-trial. Most parents don't realize that post-trial is like a whole nother trial. Your final orders don't just automatically appear after your trial and the judge has given their orders, right? After these orders are given, now you've got to get them entered. Okay? So in order to get those entered, you have to have your order written up because it's orally given by a judge. In some places, judges, they give them orally, but then they may write opinions or following that, but you can challenge those. And that's what happens most of the time when you've argued parental rights, because the judges kind of ignore them and deny them and